The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near, and they will be heard. God save the United States and this honorable court.
Please be seated. Good morning, everyone. Good morning, Judge Murphy.
Good morning, Judge Matheson and Judge Federico.
We hear you loud and clear, so I think we're good to go. We will start the morning's cases with United States versus Mayfield, number 255013. Counsel, you may proceed.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court. My name is Ryan Villa. I represent the appellant, City Mayfield. I'm going to endeavor to reserve 2 minutes for rebuttal. Your Honor, we ask that the court reverse the convictions of Ms. Mayfield below, both because of a violation of Miranda when evidence of her invocation to silence was introduced to the jury, requiring reversal of all counts for which she was convicted, and as well because insufficient evidence was presented that she committed the crime of perjury. Thus, on remand, that charge should be vacated and retrial barred due to the principles of double jeopardy. I'd like to actually start with Miranda, which I recognize is different than the way the briefing came out. But the critical point with respect to Miranda is, in the context of what we have sort of referred to as Doyle error, is that this evidence was substantive evidence of Ms. Mayfield's invocation. Doyle, the lead Supreme Court case, was about impeaching a defendant who testified about things they did or did not say to police when they were initially interviewed. There's a lot of cases in this court and the U.S. Supreme Court dealing with Doyle error in that context. This is a different context. I think it still fits into the umbrella of Doyle, but here this is substantive evidence of Ms. Mayfield's invocation when she didn't testify. She elected not to testify at trial. That was never cured by the trial court. It was never stricken. The jury was never told to disregard that evidence. And it came at perhaps the most critical time, the most critical piece of evidence that the government presented against Ms. Mayfield.
Counsel, do you think that the debate on this issue on appeal centers on the plain error steps 2 and 3? In other words, do you see the government's argument going more to those aspects of plain error than just whether there was an error itself?
I do. You mean the government didn't directly concede error in the answer brief, but they did admit that it was improper for the detective to testify about her invocation of silence.
Could you then put your arguments in those terms? In other words, there was error, assuming there's error, why was it plain, and why did it affect your client's substantial rights?
I think that what's important is the critical piece of evidence against Ms. Mayfield, which the government argues as a reason to find her, the evidence sufficient for perjury and, that there's not harmless error, is Ms. Mayfield telling the investigator in his police car a few days after the shooting that Ms. Davis did the shooting. That was the investigator's testimony. Ms. Mayfield's testimony at the grand jury was different. She said, I told the investigator what I heard from others, that Ms. Davis did it. But regardless, the government cues in on Ms. Mayfield's motive. So if she's lying to the investigator that Ms. Davis did the shooting, which really by the time of trial, there's no dispute that Mr. Atkins did the shooting, not Ms. Davis. If she's lying to the investigator, that shows a motive to commit perjury. A grand jury shows a motive to obstruct justice for which she's on trial. And right before this supposed lie to the investigator, she had invoked her right to silence, said, I don't want to talk to you. Now, we as practitioners, jurists, we understand that's not supposed to be used as evidence, but a jury doesn't know that. That's why it's prohibited. That's why the U.S. Supreme Court in Hayes called it some of the most prejudicial evidence you can admit at trial, because a jury looks at that and can infer without any further instruction from the trial court that that supports Ms. Mayfield's motive to lie. First, I'm going to invoke my right to silence. I don't want to talk to you. Then after I think about it for a few minutes and change my mind, I'm going to talk to you, but I'm going to lie. I've had time to...
Well, just one kind of almost a follow-up to my initial question about the plain error steps. Both in your brief and I think what I'm hearing this morning is you seem to be focused on linking the Miranda violation to the perjury conviction. Now, I also think you're arguing in your brief that if we agree with you on the Miranda error and plain error, that it goes to all of the counts. But it seems like you're zeroed in more on the perjury count. Is that an accurate understanding of your argument?
It is. We certainly spend more time on the briefing with perjury because of motive to lie is so essential to that crime.
Counsel, the testimony about the rights invocation, my understanding is that it was only said once at trial. Is that accurate?
That's correct.
And then immediately thereafter, the witness testified that then she did, in fact, agree to talk with him and then spent the bulk of the testimony sort of relaying what that conversation or the statements that she gave to the officer. Is that also accurate?
Yes.
Okay. So how was this, what I'll phrase as a passing reference to a rights invocation, used against Ms. Mayfield at trial? Was it argued by the government in closing? Was it in any way highlighted other than that one passing reference?
The government nor defense counsel argued it in any way to the jury in closing. It was just sort of ignored, right? And nobody asked the trial court for any remedy. But that doesn't prevent the jury from using that piece of evidence in conjunction with the government's argument, which was that when Ms. Mayfield told the investigator that Ms. Davis fired the shots, not Mr. Atkins, that she was lying. Ergo, she had a motive to lie. Thus, that's why she would lie at the grand jury. That's why she would try to obstruct justice to protect her son, Mr. Atkins, and point the finger at Ms. Davis.
Yeah, but how would her rights invocation in any way give rise to an inference of motive to lie? I mean, her motive to lie was pretty obvious. Wasn't it based upon her relationship with the defendant being her son? And then the other woman who I think a grand jury, she said, was her daughter, not her biological daughter, but clearly a close familiar relationship. So how would the rights invocation weigh against the relationship she had with the defendant compare in terms of a motive to lie?
Certainly, I think there's a separate argument for the parties to make that she would have a stronger motive to protect her son than her non-biological daughter, who she knew, according to her testimony, for a shorter period of time. I think it was 4 years or around that time frame. However, that doesn't change the fact that the jury can use the invocation as sort of the setup. I need to formulate my thoughts. I need to figure out what I'm going to say, that my initial, according to the government's truth, if I say right away without invoking my right to silence, is going to come out. So I'm going to invoke my right to silence after being told Miranda, so now I can think about what I want to say and tell you a lie, according to the government's theory of the case, as well as support the motive, which the government did argue this, support the motive to obstruct justice. I mean, the Facebook Live video, which is the primary piece of evidence about obstruction of justice, was a video sent by Ms. Mayfield to the mother of one of the witnesses because they knew each other, and not necessarily, what I would call a direct threat, right? The classic, if you show up and testify, I'm going to hurt you. It's more of, hey, your son's no good, your son's a bad person. And part of that, of course, was whether he was going to cooperate at trial. I mean, we're not challenging the sufficiency of evidence with respect to that Facebook video, but it's not the strongest obstruction of justice case, so the government needed to present evidence of motive. And certainly there's motive because it's her son. But there's also, a reason why we determine that Miranda invocations are so prejudicial and can't be heard by the jury. And if it's a different case, right, part of the discussion about perjury conviction is what inferences can we draw from circumstantial evidence? If it's a murder case where you've got DNA and blood and eyewitnesses and guns and those sorts of things, someone's invocation really isn't that critical. But when it's a perjury case and an obstruction case, where everything sort of hinges on Miss Mayfield's motive, and especially her motive to lie, the invocation becomes much more prejudicial because the jury can draw that inference that that's why she invoked, so she could figure out a story to tell, a lie to tell.
Counsel, can I ask you about the perjury conviction? The statements at grand jury that I think, from reading the briefs, are probably most at issue is her response that she did not see who shot the victim. Is that an accurate recitation?
It's difficult to discern. I think if you look at trial, it's all about who was the shooter.
Yeah.
Right? Was it Miss Davis versus Mr. Atkins? I think on appeal, when we slice it up, the way you characterize it is pretty accurate. There are some secondary statements the government points to, but that's the primary.
Well, given our review of a jury verdict here that did convict her beyond a reasonable doubt, and the deference we give to that verdict, how can we reverse here for insufficiency when she also gave testimony about that she was looking directly at? I think his name was Mr. Brown, and she's sitting right next to them. I mean, couldn't a rational juror conclude that she wasn't being truthful, that she had no idea or didn't see who shot him? Like, why is that so obviously false that we would not give deference to a jury verdict here?
Well, two reasons. One, the literal truth defense when it comes to perjury, which makes inferences different than in the normal case. And the other reason is materiality, which I'll start there. We're talking about grand jury testimony, so the standard is there probable cause to believe Mr. Atkins was the shooter, Mr. Atkins committed the assault. That's what the grand jury was asked to decide. And her testimony at the grand jury provided probable cause for them. I mean, she testified to the grand jury that they were there, that Mr. Atkins and Miss Davis were in the front seat, that the shooting came from the front seat, that she didn't see which one of them shot, but that she heard it, and that she had looked away when the shooting part occurred. That provided probable cause to the grand jury that Mr. Atkins was the shooter. It was left for a later day to decide, is that self-defense or those sorts of things. So the standard at the grand jury makes her testimony does provide probable cause, and for the perjury prosecution makes it not material the way she described it in the grand jury as who was the shooter. I mean, it had to be either Miss Davis or Mr. Atkins.
Counsel, on the perjury conviction, I wasn't clear on whether you were making an argument on sufficiency relative to the mens rea element, the knowledge element. Are you making any argument about that?
Not directly. I think it's related, but really it's the two elements that we focus on in the brief and that I'm focused on today was the statement false under the literal truth idea, and then second, was it material?
Does it matter that the alleged false statements weren't laid out specifically in the indictment or the jury instructions? What's your understanding of how the government actually presented discrete alleged false statements to the jury at trial?
Well, to be fair, the entire transcript was admitted as an exhibit. However, the testimony and the arguments from counsel all focused on who was the shooter. Was it Miss Davis or was it Mr. Atkins? And then, you get into, well, investigator Shanks says she told me Miss Davis was the shooter. She testifies to the grand jury. I told Shanks I heard Miss Davis was the shooter. And there's some back and forth, too, in the grand jury about the things she saw on video. Apparently, she was shown the video that that morning
Well,
versus
could I
what
just-
she saw.
Could I just interject? Because
Sure.
I was trying to break this down a bit more to extract what I thought were maybe the statements. I mean, one was nobody discussed the shooting during the drive home. Wasn't that one of the alleged false statements? Let
That
me
is-
just go
yes.
through them and you can tell me. She didn't see any firearms in the car. She didn't know who shot Mr. Brown. She didn't see the shooting. Are all those statements in play here as far as you're concerned?
They're all in play because they were admitted as evidence in the transcript, yes. However, I argue all of those, with the exception of who shot, are not material. Did she see Mr. Brown have a gun? Did she see Mr. Brown reaching for a gun? Were not material to the grand jury because the grand jury wasn't deciding self-defense. I mean, if she gave that testimony in a jury trial about self-defense, then we have a different argument. But they're not material to the grand jury presentation. What was material was who was the shooter. And that's where literal truth and materiality come into play. And I see that I've run out of time. May I just briefly conclude?
Please do, but before you do, let me make sure. Judge Murphy, do you have anything further for counsel?
No, I do not.
Why don't you sum up?
Sure, just so to sum up, back to who was the shooter, it wasn't literally false, or the government didn't carry its burden for the literal truth defense, which is sufficiency because Ms. Mayfield's grand jury testimony did implicate Mr. Atkins. And it wasn't material in that context because in the grand jury, we're just deciding probable cause. We're not deciding beyond a reasonable doubt who was the shooter. No, thank you.
Thank you, counsel.
May it please the court, Thomas Duncombe for the United States. The government wins this appeal because a rational jury could have found that the government proved beyond a reasonable doubt both the materiality and the falsity of Ms. Mayfield's grand jury testimony, and because there was no Doyle error in this case, because Officer Shank's stray, unsolicited remark did not constitute the use of post-arrest silence by the prosecution.
So you're arguing no error at all?
We are, and we elided error and plain error a little bit in our brief, and I apologize for any confusion that caused. But part of the reason is because most of the cases in this court on Doyle error are on preserved errors. And so they either assume or the government concedes that whatever the statement was, it was an error, and not only an error, but it was an error of constitutional proportion. And the trial stopped, and there was a curative instruction, and so you have those cases like Williams and Louder that are in that vein. In this case, we assert that there is a difference between an ill-advised comment and an error, which is a term of art for purposes of this court's review. So
What case is, what's your best case on that term of art?
well, this court's jurisprudence in general talks about whether there's an error, whether that error is plain.
Well, I'm talking about what you said a minute ago. It has to be an error of, or it has to be a matter of constitutional proportion. Why wasn't this one of constitutional proportion?
Yes, and to be clear, the cases that talk about whether it was an error of constitutional proportion are cases where the error is preserved. And so they...
It has to be an error, though. So what
Yes.
makes this an error?
Well, the Lane case is one, I believe that's 1988 from this court, that says merely bringing up in one reference the defendant's invocation is not a Doyle error because it doesn't constitute the use of the defendant's invocation against him or her. There was a case, and it may have been Lane, and I may be mixing up the facts, but where the prosecution referenced the defendant's invocation in an off-the-cuff way, and that wasn't the use of post-arrest silence against the defendant. So the cases do support that there's a difference between an inadvertent comment that shouldn't have been made and an error for purposes of plain error review, or in most of the cases that this court has thus far, harmless error review.
But can't inadvertent comments, as inadvertent as they may be, still be error?
They can, but in this context, the error that Doyle speaks of is not just the mentioning of post-arrest invocation, it's the use by the prosecution of post-arrest invocation. And there was no use here.
So I'm trying to understand what the rule statement might be based on your argument, that if there is reference to Miranda and invocation of Miranda, as long as, and there's no curative instruction from the court, as long as the prosecutor doesn't say anything more about it, then there's never an error.
No, I didn't say there was never an error, but the cases do support that there is daylight between the prosecutor or the government witness made an off-the-cuff reference, and that is always an error. And if it's such a stray remark, if it's so off-the-cuff that it doesn't constitute use, which again, the case law is use, not mentioning, that's not an error. But in any event here, even if you strongly disagree with me on that point, there was no plain error here because there was no use for the purpose of, for any purpose. This was...
When the trial judge heard the witness testify about a rights invocation, why wasn't it sort of plain at that point that the trial judge, sua sponte, should have interjected with a curative instruction?
First of all, there is no case from this court or any confluence of circuits that says that that is a plain error if there's an off-the-cuff, unsolicited remark. The cases say that the error and the plain error would be use of the defendant's post-arrest silence, either as evidence of guilt or evidence of impeachment. We didn't have that here. And in the cases like Williams and Lauder, when they're in the constitutional harmless error analysis, either the government concedes or the court proceeds directly to, was this harmless beyond a reasonable doubt, bless you. And in those analyses, they talk about the fact that it only came up for a few minutes. It was not repeated in closing. The government didn't intend for that to come out. And so they talk about those things in the context of whether it was harmless beyond a reasonable doubt.
Well, that's all the hindsight review. I'm talking about the moment the witness testifies about that invocation, because as I understand Ms. Mayfield, part of the argument that's been made is this is said before the jury, and it's sort of a setup then towards her statement about who had done the shooting, and then her motive, what was going on in her head, her reasons for making these statements, is essentially the whole case, what she's charged with. And so are you saying that we only focus on the, quote, use, in that a trial judge sitting in the courtroom observing a witness testify about a rights invocation is just supposed to sit back and say, well, let me see how this plays out. Let me see whether the prosecutor argues it at closing. Let me see the cross-examination of this witness, and then only then I'll decide whether there's a curative instruction?
No, and you're absolutely right that when we're talking about a hindsight review, it's different than when we're talking about prospectively. I think everyone in this room would agree that we would instruct judges, even if it seems inadvertent, to stop the proceedings and say, hold on, I want to address this, and I want to make sure the jury understands this. But for purposes of the case law, there is a difference between a reference and use. And in some of the cases, because they've moved on to, is this a constitutional harmless error, or is it harmless beyond a reasonable doubt? They talk about that, who brought it up, how long was it dwelled on. They talk about that in the context of the harmlessness. And even if this court views it in that light, that we should view it as a plain error, but talk about things like how long was it? Was it intentional? Did they harp on it? How strong was the evidence otherwise? If this court purely looks at that in the substantial rights column, the government still wins on that issue. And not just because.
So you're saying if we skip over the first two, whether or not there was error and whether or not it was plain, and go to effect upon substantial rights, is that the lack of use, as you argue it, is an important factor in that analysis?
Yes, it is. And so.
Part of the argument.
Yes, I'm sorry, Judge Murphy. If we move on to harmless error analysis or plain error substantial rights analysis, the courts apply the Massey test, where one of the factors is what was the extent of the use, and what was, who brought it up first, and how was it brought up. So you get into things like that. We would assert that if it's not something that disqualifies this from being an error and not something that qualifies this from being a plain error, then it certainly is something that weighs against this being a violation of Ms. Mayfield's substantial rights. And I want to make clear, we disagree profoundly with my colleague's assertion that this came at the most critical time of the trial for purposes of the perjury charges. When the invocation was mentioned by Officer Shanks, that was the first witness of the trial. And then the later statement to Officer Shanks of Davis was the shooter, the jury would not have been in a position to realize the importance of the statement, not the invocation, but the statement, Davis was the shooter, until the last day of trial, when Agent Nechiporenko testified and they saw the transcript of what Ms. Mayfield had told the grand jury. It was only then that it was discussed that there was a discrepancy between what she had told affirmatively Officer Shanks about Davis was the shooter and what she had told the grand jury, which is Brown told his gang buddies that Davis was the shooter, his gang buddies told a white guy named Benjamin that Davis was the shooter, and a white guy named Benjamin told me. That's what I meant when I told Investigator Shanks. So this would most likely, being the first witness of the trial, have been a blip on the jury's radar when they were going back and deliberating on what are the inconsistencies in Ms. Mayfield's statements.
Counsel, you just mentioned the grand jury transcript. So can you help us understand the discussion we just had about which statements were highlighted to the jury as being false and material that supported the perjury instruction? Because as it's been presented to us, the whole transcript was admitted into evidence. I can assume the jury wasn't just told, pick through there and find what you think is false. So which statements in the government's view are really at issue here?
No, and the jury was not told pick through the transcript and find which you think are false, but it's important that because we're in a sufficiency of the evidence analysis, and I do want to answer your question directly and talk about some of those specific statements, but it is important that what you said earlier, Judge Federico, that we are in a situation where they did not have to allege in the indictment, these are the specific statements from the grand jury transcript that were false. And the Strom case, in I think footnote 14, talks about the fact, even if we disagree with the government that this particular statement that they've highlighted for us was false, there were plenty of other statements for the jury to select from. And that's the case here as well. So some of those.
So counsel, that's an interesting argument. Does that mean that under our standard of review for sufficiency, if there was a statement in the grand jury transcript that the government didn't affirmatively present to the jury as false, but this court on review thought it was false, could we affirm on that ground?
Yes, 100% yes. And the reason is because of this court's sufficiency jurisprudence. This court takes all the evidence, both direct and circumstantial, and the reasonable inferences to draw from that evidence. And that evidence included the grand jury transcript, which was Exhibit 61. And you can see the exhibit list on page 377 of Volume 1.
Even if the statement wasn't mentioned at all?
Even if the statement was not mentioned at
As
all.
long as the exhibit's there and they can look at it, and we can look at it and decide that there should be a perjury conviction.
Yes, this court's review on sufficiency of the evidence is very deferential. Now, having said that, this court need not do that in this case because there were a number of statements that the government did highlight to the jury that were false. Most notably, all the statements about I saw exactly what Brown was doing when he was both in front of the car and to the right of the car and just back a little bit with where he was standing, with what he was doing with his hands, with the fact that he had the gun out in his hands. And then there is no good reason given why she wouldn't have seen him being shot. She says, after I heard the gunshots, I got scared. And that's her explanation for why she didn't see Brown getting shot. She didn't see someone shooting. And then there's other inconsistencies from there, most notably from the transcript. She says that Brown, when he was standing in front of the car and in front of the store, pulled the gun out and was threatening with it.
Well, counsel, on some of the other, Mr. Villa was saying earlier that at least some of the statements were not material. Do you think the issue of materiality is a little closer for some of these other ones? I'll give you an example. The statement about nobody said anything on the drive home, how's that material?
So first of all, and I want to answer that question, but first of all, I just want to orient the court in terms of materiality. Just because this was a probable cause determination and not a beyond a reasonable doubt determination, that doesn't mean that materiality means something less than it does when you're in a trial. Something that would have had the natural tendency to influence the grand jury's determination or would have had the potential to influence that determination would have been material.
Is the analysis different? And maybe this goes in your direction. Is the analysis of materiality different in the context of the grand jury than in the context of trial because the grand jury just needs to find probable cause?
No, and I see that my time is
ahead.
out, but may I? The analysis is not different. And all the cases, whether you're talking about grand jury testimony or trial testimony, the standard is the same. If you look at Durham or you look at Strom, the standard for materiality is, did it have a natural tendency to influence the grand jury, or was it capable of influencing the grand jury? And the two questions that the grand jury had to answer were, number one, did Atkins shoot as opposed to someone else? And number two, did he shoot without justification? In other words, did he shoot with the intent to do bodily harm, as alleged in the indictment, or did he shoot because he was trying to protect the other people in the car from a threat, which is a lot of what Ms. Mayfield was testifying to in the grand jury. The affirmative testimony about he was standing in front of the car, not only had his gun out when he was standing behind the car and to the right, but had his gun out and was threatening with it in front of the car. That's something that's demonstrably false from the video that we have in this case.
Thank you.
Can I
So
ask one more?
we have another question.
Mr. Vila a moment ago said that by the time the Mayfield trial began, it was no longer in doubt that Mr. Atkins was the shooter. Can you help me understand why that was, and was the jury told that, or how did they know that?
The only way that the jury would have known that is that Mr. Atkins got up and testified that, yes, I shot him, and said that essentially it was in self-defense. And his sister Miko testified that Brown had the gun out. And the jury may have been able to infer that from the cross-examinations of some of the government witnesses, focusing on the fact that Brown had a gun, focusing on the fact that Brown was clutching it at some points during the evening. But other than that, this was not, but certainly by the grand jury, which was long before the trial, it was very material who exactly was the shooter. And they were, Ms. Mayfield was not the only grand jury witness, but it strains the English language to say that her testimony supported probable cause on any of those points. Thank you.
Thank you, counsel. I think we've exhausted the allotted time, so we will consider this case submitted. Thank you for your arguments. Counsel are excused.
Thank you.
We will now hear United States versus McBee, number 255049. Counsel?
Good morning, Your Honors, and may it please the Court. My name is Malia Castillo, and I represent the appellant in this case, Mario Terrell McBee. I intend to attempt to reserve some time at the end for rebuttal. At the outset, I do want to say that we briefed 3 issues in this case. One of those was a Second Amendment issue. We recognize that pursuant to Vincent B. Bondi, that is foreclosed, so I do not intend to argue that. The government argues the standard for review for the remaining issues is plain error. So I do want to stress that the only issue at trial was whether Mr. McBee had knowledge that he possessed a gun and ammunition. Mr. McBee was a Black man who showed up to the Claremore Indian Nation Hospital. He was unconscious, actively overdosing. The government acknowledged in its opening that the main issue at trial was knowledge. Specifically, they asked the jury to evaluate whether Mr. McBee, had knowledge of possessing a particular pistol and whether he had knowledge of possessing ammunition. Likewise, the defense counsel in its opening said that we do not dispute that he possessed the gun, that he possessed the ammunition, that knowledge was the central issue for the jury to decide. Before testimony began, defense counsel and the government's counsel had entered into 2 stipulations, and that was read to the jury before any testimony was given. The first stipulation recognized that the parties agreed that Mr. McBee was a felon at the time of the offense conduct on April 23rd of 2021, and that he knew of his felon status. The second stipulation that the parties entered into stated that all of the offense conduct and the Mr. B were present in the Northern District of Oklahoma. So really, with the remaining issues, what this boils down to is whether or not, whenever Agent Williams got up to testify and said that all of the elements have been met, if that phrase, that all of the elements have been met, was inclusive of every element, if he was directly testifying to each of those individually. The first of which is the knowledge element, that he knowingly possessed the firearm and ammunition. The only issues left to prove because of the stipulations were the interstate nexus, which they had Agent Williams testify to, and then the knowledge element. So most of the trial was geared towards proving Mr. McBee's knowledge. So we maintain that yes, that expressing a general opinion, going back to what the central question is here, that a person is guilty, that all of the elements have been met, necessarily means that that person is testifying to each of the elements individually. Just because he didn't enumerate, that Agent Williams didn't enumerate, does not mean that the jury wouldn't have realized that he was talking about each of those specifically.
Counsel, what if Mr. Williams had just said, we didn't investigate further because we had all we needed? Would that be an error?
No, I don't think so, because there was actually another witness, FBI agent David Young, who said something similar. He was asked, why didn't you go out to further investigate? And he said, I think this is a semi cut and dry case, is what he said. And I think the semi part of that allowed for the jury to make an inference. And I think that was, I guess, squishy enough that the jury could evaluate that and then evaluate the evidence presented.
Well, I guess my question is, what's the difference? If he says we had everything we needed to go to the grand jury, we didn't look in the car because we thought we had everything we needed, is it really the use of the word elements? Does that make all the difference?
I think it does in this case because when when the jury gets their instructions, all the elements are enumerated. The very first one is the one about knowledge, that's an issue. But then also, sorry, can you repeat your question?
Well, it just seems like if you didn't have an argument with, I guess the question is, would you have any argument if he hadn't used the word element?
As long as he didn't use anything that was substantially similar to the mens rea element to knowingly, I don't think we would have an argument. I think specifically because he did say element, that the jury could put two together, that he was commenting on every single thing. And I think too, if it were framed in a purely investigatory sense, which I know that was how it was sort of presented, within the realm of his regular scope and duties, then that would be a different discussion. But because he went outside of his expertise and said that every single element, not the ones that I am responsible for as a, case agent or as the nexus expert, if he had framed it that way, I don't think that we would have an argument. But I think because he went outside of that and started testifying to the mens rea element, or all the elements.
Well, that actually leads to a different question. Agent Williams was called to be the nexus expert, correct? And,
Yes.
I read through the transcript, and there was fairly extensive foundational testimony to qualify him as a nexus expert. And then the prosecutor moved to have him admitted or qualified.
Yes.
Again, as a nexus expert. All right. But when he made this statement, this wasn't, this was not just about nexus. Is it obvious that when he gave this particular testimony that you're challenging, that he was testifying as an expert?
An expert as to nexus, or an expert just generally?
Was he generally? Was that actually expert testimony, or was that agent, lay, witness testimony? Yeah,
so I think it could fall one of two ways, that, he was testifying just as a nexus expert, but I think because of how he was certified and the questions that were asked and the answers that he gave leading up to that, he talked about his 26 years in experience. He was asked about how many of the cases that he investigated involved guns, and he said, 75 to 80%. He had, went at length talking about how many guns he had interacted with in his career, how much ammunition he had looked at in his career. And so I think from a jury's perspective, they could see that as, okay, he is also an authority on, investigative techniques, what needs to be done in a case. He should be familiar with what needs to be proven and that sort of thing.
Counsel, can I make sure I'm tracking on your argument here? The 704B refers specifically to mental state or condition.
Yes.
As I understand your argument, you're saying that because Agent Williams used the words elements, it would have been obvious to the jury that by elements, what he really meant was knowledge, because that's the only element that was at issue.
Yes.
Do you have any cases that have taken that sort of inferential leap, that the jury has, it's just clear to them that there's only one element at issue, and a witness who doesn't even refer specifically to a mental state or condition, that's found to be 704B error?
I think the closest one that we have is that Mary Boy case, because in that case, it was thoroughly discussed that knowledge was the only element, because...
Well, in Mary Boy, though, the witness specifically testified about recklessness.
Correct.
That was the mental state at issue, and that was the testimony that the agent said several times. That would be reckless.
Correct.
Was the testimony. So that was square on point to 704B. That's what I'm getting. I'm trying. So if it's not Mary Boy, or at least hint.
Correct.
Because that was testimony specific towards mental state or condition. Are there any other cases besides Mary Boy that you would point us to? I
think Diaz also is beneficial for us on that point, because in that case, the court said that if, and this is the Diaz from the Supreme Court 2024, because I know there are two Diaz cases, but that one talked about if, in a hypothetical, if all defendants knew, or all couriers knew a certain thing, or if some of them knew a certain, had that knowledge requirement. All couriers would include the defendant, and so that would impart that knowledge that the expert would have been testifying to the defendant. And so the court had a discussion about how that would have changed the outcome, instead of saying, some couriers, might know. And so I think, to your point, that would be our strongest case.
And help me understand a potential overlap between your 704B argument and a 403 argument. Are those distinct, and how should we think about those?
So I think the 403 argument goes more towards our second issue, being outside of the scope. I do think, though, that this is, prejudicial, and that this gets to the main question being, if he's not commenting on elements in an enumerated way, if he's kind of lumping them all together, is he, necessarily commenting on all of them? And I think that really, where that comes into play is our first and third prong. So I guess, to your point, the prejudice issue. So if there is an error, then 704B is necessarily violated, because he is an expert.
Well, I thought the 403 argument was being made in conjunction with your Rule 702
Yes.
argument. So what is your 702 argument then?
So the 702 argument is that he was recognized as a nexus expert, and that essentially he could not have in either way testified to in a lay opinion about Mr. McBee's knowledge, because he didn't have firsthand knowledge of what Mr. McBee's mental state was. He, in fact, didn't even interview him. But then he also couldn't testify in an expert position about his mental state.
Why couldn't the fact that he testified to being involved in, I think he said, thousands of investigations, is that what he said?
Yes.
Including 20 years with ATF, lots and lots of gun cases. Why wouldn't that be Rule 702 experience-based testimony?
Because I think he still doesn't have specific knowledge of what Mr. McBee's mental state was. He didn't.
Isn't mental state, in most cases, including this one, the product of inferences from circumstantial evidence? And didn't he have the information that everyone else had, that the ER nurses went out and they found the gun?
Sure, I do think that he's still encroaching on the jury's role in as fact finders, and so I don't.
You're not making an argument that he's expressing a legal opinion then about the elements.
I would in the context of the 704B argument, but 702, it's more that he's going outside of his expertise, if that makes sense. Did that answer your question?
Well, I was just interested because we started with 403, but I thought that 702 was the lead up.
Yeah, yes, it was. And so, yes, it was prejudicial, like I said, because he does not have any knowledge, and because of his role as an investigative officer with all of this experience, I think a jury would tend to trust him more than, say, a kind of run-of-the-mill, like, witness who, witnessed a crime but wasn't a law enforcement officer.
Counsel, I have a question regarding going back to the early part of your argument. Did I understand correctly that you thought there was some importance that he used the word elements?
Yes.
All right. I looked at the jury instructions, and I'm going from memory. A lot of times they use the word elements in an elements instruction. I didn't see that in this case. In fact, as I looked through all the jury instructions, I thought I only saw one reference to the word element. Am I wrong in that?
I can't recall off the top of my head. I think with the jury instruction.
Well, if you can't recall, let me ask this. Would that make a difference in your argument that when he says elements, that's not so important, and it could really mean It has no particular meaning to a juror, and if there's nothing in the jury instructions, it can just be part of, his investigatory process, and that is that we had everything we needed type testimony.
I do think it's still.
Why is that an improper analysis?
I think because even if the jury instructions don't specifically say element, and sorry, I recognize that my time is up. Would you like me to continue?
Please do.
Okay. Sorry, I lost my train of thought. So just because the jury instruction, if it doesn't say element, it still enumerates what the jury must find in order to get a conviction. And if you have an ATF agent, whether he is testifying in his expert capacity or not, getting up on the stand and saying, all of these things that you need to find in order to get a conviction are met, whether the term element is used or not is, I think, not irrelevant, but maybe not as important, because the idea is that everything that he felt was needed for a conviction was satisfied.
Right.
Thank you.
Counsel, appreciate your argument. We'll now hear Lamont.
Good morning. May it please the court, counsel. My name is Lena Alam, and I represent the United States. I'd like to begin with Judge Murphy's last question. He's exactly right. On page 132 of volume 1 of the record, the jury instruction number 14, which presents the elements of the offense, does not use the word elements. It just says that in order to find the defendant guilty, you must find each of the following beyond a reasonable doubt, and then it lists each of the elements of the offense. The fact, the defense's reliance on Agent Williams' reference to elements, the fact that Agent Williams' testimony did not substantively track the language of the jury instructions demonstrates why, in this case, there was no 704B error at all. Agent Williams not only did not opine about Mr. McBee's mental state, he did not mention the mental state required. He did not mention Mr. McBee's mental state. He did not engage in hypotheticals suggesting that the mental state was met, like in some of these cases.
Counsel, why wouldn't this point about the jury instruction fit a little more comfortably in either step 2 or 3 of plain error analysis? In other words, yes, the word element may not have been used in the instruction, but the jury was instructed that you have to find 1, 2, 3, 4, and he did talk about all the elements. Maybe that doesn't create a tight connection, but it does still raise an issue. And so why isn't the more comfortable fit be if there was an error, it wasn't plain, or it didn't affect substantial rights?
I think I'll have to echo my colleague from the last case and say this is both. But here, all of the 704B cases that focus on whether an agent opined about mental state. There was nothing here that suggested that when Agent Williams spoke about the elements, he was talking about mental state at all. In fact, looking at Agent Williams' testimony, particularly on redirect, I think at page 192 of volume 3 of the record, it's not even clear he understands that the mental state is an element of the offense. When he says it was on his body, the element of the crime is, and then he trails off and says it was the firearm was on his person. I don't need to fingerprint him because it was on him. It was in his possession.
As Ms. Castillo pointed out, though, the trial was all about knowledge, right? I mean, that's what both sides are arguing about in front of the jury. They're getting knowledge thrown at them from day one to the end of trial,
Yes.
closing arguments, everything else. And why wouldn't, in thinking about this, And going back to Agent Williams, why wouldn't they say, well, Agent Williams must have thought everything was satisfied?
Because the questions to Agent Williams didn't concern Mr. McBee's knowledge at all, and his answers didn't either. What they concerned was the adequacy of his investigation and the adequacy of the FBI's investigation. That portion of Agent Williams' testimony had nothing to do with the question of Mr. McBee's knowledge. It had to do with whether they had conducted an adequate investigation. And because Agent Williams...
Don't investigations, I mean, if knowledge is going to be an issue, don't investigations ever look for evidence about knowledge?
And they should, but the question here and the context in which Agent Williams was being asked these questions was the context of, did you have enough evidence for the investigation, i.e. under a probable cause standard, not under the beyond a reasonable doubt standard that the jury was being asked to apply. Furthermore, the reliance in Agent Williams' testimony on the word elements and the fact that the jury was never told that knowledge was an element suggests that Agent Williams' testimony could not be read to imply that he had that knowledge, because his reference to elements was not what the jury was instructed they had to find.
Counsel, can I ask, you just said the jury was never told that knowledge was an element, but the way I've understand the presentation of both parties is that knowledge was really the only thing at issue. So so whether they were told formally it was an element, didn't the jury know that really the only question they had to decide is whether the gun that was found on Mr. McBee, whether he knew it was there?
Absolutely. And to the extent that I suggested that they weren't told that they had to find his knowledge, that was not what I intended to say. What I meant was that the word elements was not used when they were told they had to find Mr. McBee's knowledge of the firearm. And you're absolutely right. They were told over and over, and particularly in the government's closing, that the only question really remaining for them was whether Mr. McBee knew. And moving forward to prong 3, the substantive rights analysis, here, very differently from Mariboy, both the fact that Agent Williams' testimony did not track the language of the jury instructions and the fact that the government never mentioned Agent Williams' testimony about the fact that the elements were met, but rather focused on all of the other evidence presented at trial in reviewing, both in first close and in second close, the evidence that showed, both direct and circumstantial, that Mr. McBee would have known about the gun that was concealed in his pants. In fact, in that second close, counsel specifically referenced the gun, and there's a picture of that gun in our supplemental record on appeal. And counsel asked the jury to find that anyone who had a gun that size in their pants and was conscious, as Ms. Mitchell testified Mr. McBee was for most of their trip to the Claremore Indian Hospital, would have known that they had that gun in their pants. And the government's focus on that direct and circumstantial evidence of Mr. McBee's knowledge, rather than on Agent Williams' passing comments in the context of the adequacy of his investigation, shows that in this case, very differently from Mariboy, even if there was an error and the error was plain, which it was not under this court's case law, even if it were, this is not a case where any error affected Mr. McBee's substantial rights.
In assessing, let's stay with step 3 for just a minute. In assessing substantial rights, is it appropriate for this court to consider that the jury notes suggested that this was a close call?
Absolutely. This was a close case, and the court can consider that it was a close case. But given the context of Agent Williams' testimony and the government's remarks in closing, to the extent that this close call was resolved by the jury ultimately in a finding of guilt, nothing in the record suggests that Agent Williams' testimony was the thing that pushed them over the edge. Rather, it was, the context suggests it was the modified Allen instruction.
Why wouldn't it be possible for, I mean, the jury, well, they found this gun. That's really the whole case, is they found this gun where they did. Both sides argued knowledge to a fare thee well. We're not really sure. Well, but, you know, we had this guy Williams who's done thousands of these cases. He must know what he's doing, and he said all the elements were met.
But he never said or even suggested that Mr. McBee knew. In fact, it wasn't clear that Agent Williams knew that Mr. McBee had to have known that the gun was there. He said it's in his possession. He addressed the element of possession, not the element of knowing possession. And so there was...
Oh, he said elements. He said all the elements were met.
Yes, and then he said the element of the crime is it's on his person. That's not the element of the crime. And the jury was not told that they had to find the element.
He didn't say it once, he said it twice.
Oh, he said it at least 3 times.
Oh, 3 times. All
Because
right.
he said it on redirect as well.
Okay.
He was eager to help, but unfortunately, it isn't clear from the record that he necessarily understood that he was talking about knowledge, and certainly neither the questions nor his answers implicated the core concerns of Rule 704B, that he stated or even impliedly stated that the defendant had the requisite mental state here. Rather, all of the discussion, particularly in the government's closing, was all of the circumstantial evidence that showed that Mr. McBee knew about the gun in his pants. And to the extent that after sending those notes to the court, the jury ultimately found that Mr. McBee knew is much more likely under these facts to have been based on that circumstantial evidence presented, as opposed to Maryboy, where the government emphasized the challenge testimony, and particularly by wrapping up their first close by talking about that testimony as a way of showing the defendant's extreme recklessness in that case.
Counsel, you mentioned this trial was a close call, and having a defendant who is stipulated to having a prior felony conviction and knowing that he was a prior felony conviction, a prohibited person, and the gun on his person. I'm just trying to understand, the closeness of the call in terms of the theory of defense that was presented. Was the thrust of the defense that the government just can't prove he knew because by the time the gun was found he was unconscious, or was it that the mother's friend had planted the gun, or sort of help me understand the context?
Like you, I was not at the trial, but from the defense closing argument, it appears that the thrust of the defense case was that Ms. Mitchell somehow planted this gun on Mr. McBee. And the government's second close addresses this, talks about how unlikely it was that Ms. Mitchell, an elderly woman who was reluctant to testify against the son of her good friend, who was volunteering to take this man to the Claremore Indian Hospital, who testified that had she known he had a gun, would not have let him in her car. The absolute incredibility of the defense theory. And so ultimately, in deciding that the circumstantial evidence, both the testimony of Ms. Mitchell, but also the testimony of Brandy Eubanks and Isaac Pinsart, the nurses who found the gun, who transferred him, Mr. McBee, from Ms. Mitchell's car to the gurney. The gun didn't come loose. The gun was firmly lodged in Mr. McBee's pants when they found it. In citing all of that evidence, it is far more likely that in concluding that Mr. McBee knew about the large gun tucked into his pants, that the jury credited those pieces of testimony rather than Agent Williams' passing reference to the elements of the offense.
Could you briefly speak to the Rule 702 argument? I didn't see much in your brief about that.
And I will say, I don't think the question here is whether Agent Williams' testimony went beyond his expertise, because the questions he was being asked were about the adequacy of his investigation. And so they were based on his expertise as and as an experienced ATF agent who had conducted hundreds of these kinds of investigations. To the extent that he was testifying about the legal standard of the elements of the offense, that may have been improper legal testimony, but that wasn't the basis of the objection. And here, certainly it was an error, let alone plain error, to allow Agent Williams to testify about the reasons he thought his investigation, he did not need to do additional investigation like additional forensic testing. And for that reason, even if there were a Rule 403 error, that error didn't affect Mr. McBee's substantial rights. If there are no further questions.
Hearing none,
Thank you, Your Honors.
thank you, counsel. Case will be submitted, and counsel are excused. Thank you for your arguments. Right, the court's going to take just a brief break. For the next case, we'll have in the courtroom only counsel for the parties and clerk's office and judges' clerks, and we'll keep it at that. But